All right. Hello and welcome to Kimbrough Legal's October webinar, Navigating Property Division During a Divorce in Texas. My name is Michelle Bell and I will be hosting the webinar, but presenting today is one of my absolute favorite people. It's Kimbrough Legal's Associate Attorney, Jasmine Avery. Attorney Avery is a passionate attorney at Kimbrough Legal and provides concierge level service to her clients. She is experienced in divorce, custody, child support, property division, mediation, and trials. Attorney Avery's compassionate approach provides support and guidance to her clients, ensuring their interests are protected throughout the process. Welcome, Attorney Avery.
I'm very, very, very excited to be here, Michelle. And I'm excited to talk about property division, which I know is something that trips up a lot of people when we talk about divorces.
Perfect. Let's get started.
Okay. And Michelle, I don't know if it's showing for everyone else, but I'm seeing like previews of the next slide as well.
Ooh, I am so sorry.
I didn't know if that was just me, my access.
This one.
Okay, there it is.
Thank you. Apologies.
No, that's okay. Okay, welcome everyone. So we're here to talk about property division as it relates to divorces in Texas. So the first thing you need to know before we talk about who gets what and how it's divided up is that Texas is a community property state. And what that means is that when you get married, there is this presumption that everything you get during the marriage, and we'll talk about what those things are, is presumed to be owned by the both of you. And so these community property laws, as the slide says, have important implications when it comes to couples in Texas and divorce and property ownership, management, and those sorts of things. So we're going to dive in deep and discuss the distinction between community property, separate property, and what you should look for in a divorce. Oh, there we go. Okay, so the definition of community property, right? We have already talked about that Texas is a community property state. What that means is that anything you acquire during the marriage is presumed to be owned by the both of you, whether it's a new home you've bought, whether it's your income, new vehicles that you purchase, a business that you start, any personal property that you get, or any debts. All of these things during the marriage are presumed to be an obligation of both of you, an obligation of the marriage. Separate property is anything you own prior to marriage, and even some separate property accrues during marriage if it's a gift to you, if it's inheritance, if it is, say, if you had a personal injury claim and you had settlement monies come from that, all of that settlement money is considered your separate property as well because it was your personal injury. And the beautiful thing about separate property is that generally the courts will not touch it in a divorce. If it was your property before the divorce began or before you were married, then it is going to remain your separate property in the event of divorce. Of course, in family law, there's always some exceptions and some what if situations in different circumstances. It can get fact specific, but generally separate property remains separate property. So division of property in a divorce. So during a divorce, community property is generally divided equally. We start from a foundation that one spouse will get 50% of all the community property and the other spouse will get 50% of all the community property. The judge is going to want to divide things up in a way that is just, that is right, and that is equitable. So unless there are extenuating circumstances or reasons why one spouse feels they should get a disproportionate share, we'll start with that 50-50 split and make it equal. As far as management and control goes, each spouse has the ability to manage and control any of the community property. So if it's a home, a vehicle, or whatever it is, one spouse doesn't have all the decision-making power, the decision-making rights, because it's a community asset. And this is a really good thing because one fear that a lot of people have is that once I file for divorce, spouse is going to kick me out of the house or spouse is going to take the car. And if it's community property, there are going to be consequences for them doing that because you both own it and they don't have a right to just take it from you while a divorce is pending. So there's no selling, disposing, or transferring any of the community property because you each have a right to control it. Debts. So debts is It is a tricky thing in family law. It's something that people go back and forth on all the time on whether community debt is such a thing and whether it exists. There is a Texas Court of Appeals case called Mock v. Mock. And in that case, it says that unless a creditor specifically says, I'm only going to go after this one spouse, whatever obligations accrue during the marriage are presumed to be a marital obligation. If it happened during the marriage, it's presumed to be a marital obligation. And section 3.201 of the Texas Family Code talks about spousal liability. And so if you act as your spouse's agent, meaning you signed up for the loan or the credit card or whatever it is with their agreement, or if it was a debt for necessary, so say you needed to take out a second mortgage, you needed a new vehicle or whatever it is, and you guys agree to that, it's going to be a marital obligation for both of you. So you're each going to be responsible for these debts and things like that. And also you have to be aware of tax implications as well. So with community property comes tax implications, especially when it comes to us talking about, like it says, capital gains and taxes, valuating the properties, and making sure we all have a clear picture of what the consequences or benefits, pros and cons are going to be for property division. So here are some strategies for equitable property division. First thing, list and value the assets. You're not going to want to go into this blind. You're going to want to make sure that all of the community property and even separate property that there is all accounted for. No one wants to try to rush into a decision and then years later you realize there was some secret account or the value of a ring was more than you thought it was and you didn't want to give it away. You want to make sure you list out everything and you have a really clear picture of what is there to be divided. Categorizing the property is very important, because we could be arguing in a divorce over property, but if we don't know it's categorized as separate property, then we've kind of wasted our time, because separate property really has no argument. It just goes to that spouse. So you're going to want to categorize the property before you start talking about dividing up assets. Is this a community property asset or a separate property asset? And then lastly, you want to consider contributory factors. So there's a lot of different factors that go into property division. If you were a stay-at-home parent, that could be a factor that contributes, that would give you a higher share of the community property. If there are childcare expenses, if there are disparities in income, whatever it is, all of these different factors can affect how the property is going to be divided up. Spousal support. Spousal support can also be another consideration, right? When we talk about income disparities, if one spouse is the high income earning spouse and the other one either has a very low paying job or no job at all, maybe is a stay-at-home parent, then we're going to want to consider that when we talk about dividing up property. Maybe that is the reason why there's a 55-45 split instead of a 50-50 split. Negotiation and mediation. Most family law cases are required to go to mediation or some other form of alternative dispute resolution before we even get to like a final hearing or trial. We always recommend it, highly recommend it, because you also want to make sure that you have a say in how things will be divided up. So in negotiation or mediation, you can express how you want things to turn out and have a say in it. But when it gets to court, you're just presenting everything to the judge, and the judge will decide either in your favor or not in your favor. And so you're going to want to try to compromise, try to reach an agreement outside of the courts. And then financial experts. This is one that a lot of people tend to just brush over. But when you are dealing with high value assets or businesses or stocks or retirement accounts or whatever it is, you're going to want some type of financial expert weighing in on it and giving you the pros and cons and the advice. Family law attorneys are not tax attorneys. We're not, real estate attorneys or anything like that. So we cannot advise you on the tax implications or give you tax advice. So when it comes to high assets, you're going to want to consult with someone else on those issues before making a decision. Asset liquidation. So in some family law cases, it is going to be necessary for you to sell certain assets, especially when it comes to real estate. The homes are typically the biggest thing that we argue about. It's the biggest player on the board. It has the most value. It has the most, not just monetary value, but there's some significance to it as well, and some emotional ties to the homes in most cases. And so a lot of times when we talk about dividing that up, it could mean selling it. It could mean transferring it. Investments or stock accounts that you have may need to be liquidated or sold in order to divide them up. And so you just want to make sure that you're considering those tax implications as well, especially for retirement accounts too. Considering future needs. So when we're talking about dividing up property, you're going to want to think long-term, not short-term, because the decisions you make in your divorce are going to affect you for years to come. When you decide to take money out of your retirement now, or to give someone 65% of your retirement, that's going to affect you when you get to your retirement years. So the court will also take into consideration other factors: age, health, earning capacity, custodial agreements, when there are children involved, and any other thing that you want to present that could have an effect on the consequences of property division. So consider the future while you're making this present decision. Then you're going to want to review any property agreements that you've already put in place. If there is a premarital agreement or a postmarital or postnuptial agreement, you're going to want to review those very carefully, because 10 times out of 10, those agreements are going to discuss how property is going to be divided. It's going to discuss who gets what is going to be classified as community versus separate, and that agreement will control. So if you signed up for a premarital agreement, when you get to the divorce, that agreement is the first thing you need to look at before asking or trying to divide up other property. Stay organized. In the initial consultations I always tell people, if you're getting ready to start a case and get this thing in the legal system, start to keep records. If you haven't already, write things down, track down receipts, history, withdrawals, deposits, whatever it is that is supporting documents for your request for property division. Stay as organized as you can. Get deeds, get property documents, bank statements, letters for loans or promissory notes, whatever it is. You're going to want to keep all of these things very organized, because if it becomes some disputed issue on whether something's community or separate, you need to have the proof to show why that asset should be categorized in the way you want it to be. Then legal counsel. Of course, I'm a little bit biased here, but this is also, just very important in general. When you're dealing with a lot of assets and community property, money, retirement accounts, whatever it is, and even if you have very little assets, you should always consult with an attorney, an experienced attorney. You should always do that, because you don't want to make a mistake on a document or forget to mention something that you may have thought was very minor, but it was actually very important to know. So just consult with an attorney to get a big picture or a generalized picture of what this is supposed to look like, because we are able to see, the forest, while you may only see a tree, because this item is the most important to you, but all the others are important to us as well. This is one thing that's very important to remember. Just because we say the word equitable when we talk about property division, it doesn't mean that it has to be a 50-50 split. Equitable does not mean equal. It just means that however the property is going to be divided, it needs to be just and a fair division of the estate. It needs to be equitable. Doesn't necessarily mean equal. It just means that we're both in a good position when this is over. No one's going to be put at a significant disadvantage because of the way the property was divided. So it's just important to remember. Okay, so here are some common pitfalls to avoid to ensure a fair and equitable outcome. 1, failing to understand community property laws. This is why we said it is important for you to seek counsel, either as representation or at least to review the documents and agreements before you sign off, because there could be some gray areas, and you want to make sure that whatever you do is enforceable in court. You don't want an order that you're going to have to come back to court over a year later because you just didn't have the full understanding of it. Not taking an inventory. It is very understandable that when you get in a divorce, you just want it to be done. And so you don't want to do all the extra documents and the research and the tracking things down and tracing and all of that. And so some people may skip an inventory. And what an inventory is listing out every asset, every bank account, every liability, and the value of that thing, so that everyone is on the same page as far as what are we dealing with. So do not skip this part. It is very important. Because if you don't have all of the information about what your spouse's finances look like, or you don't know exactly what their income looks like, you're going to want this inventory so you make an informed decision. Not considering tax implications is also a common pitfall. Like I said, family law attorneys are not tax attorneys. And so you cannot solely rely on our advice for, how will me taking out this retirement affect me in the long run if I take it out now prior to reaching retirement age? Or how will this affect me if I don't require my spouse to refinance the home now? Tax-wise, we cannot give you advice on that. Hiding or concealing assets. I know it may be tempting for you to try to hide that, rainy day account that the spouse may not have known you were saving up money for, but you cannot hide anything. And that's because our Texas law, if you don't disclose an asset during the divorce and we find out about it later, and by we, I mean your spouse or ex-spouse at that point, it can be subject to future division. So if you don't disclose that there was this account that had $50,000 in it and your spouse finds out 6 months later, you can be taken back to court over that issue and be required to litigate that and divide it up fairly. Emotional decision-making. It is of course understandable that this is a very emotional process, and we all understand that. This is not an easy thing to do. It's not an easy decision to make. And you want to feel heard and seen and as if you're not being taken advantage of. And we 100% understand that. But you have to be able to put emotions to the side sometimes so that you're able to make a logical and rational decision that will set you up for success later on down the road. Because while it hurts right now and you want to make this decision, you have to know, how is this going to affect me 5 years from now when I'm healed and whole and living my best life? You're going to want to still not have seller's remorse. You're going to want to not have any regrets. So don't make decisions out of the emotions you feel. And ignoring debts. Some people will say, well, if this was their debt, it doesn't matter. That's something he or she said they were going to pay for while we were talking about things. Don't rely on oral agreements. There are so many cases where the spouses are talking and everything's fine and they make oral agreements and don't get it in writing. And then the other spouse may fall back on their word and you were counting on them to hold up their end of the bargain and it may not happen. So don't ignore anything, debts, assets, or liabilities. Overlooking retirement accounts. Generally, if both spouses have retirement accounts that are just about equal, more often than not, the spouses will say, you keep yours, I keep mine, just to keep it clean across the board. But do not do that without knowing the value of the retirement, because if spouse A has $10,000 in retirement and spouse B has $90,000 in retirement, that's a huge asset moving across the board of division, and you don't want to ignore that. Not getting professional advice is also a common pitfall. It is 100% possible for you to represent yourself in a divorce. Lots of people do it and they do it successfully. You can do that, but if you have lots of moving pieces in a divorce, it is always wise for you to get a second opinion or to get representation so that everything is done correctly procedure-wise. Another pitfall is agreeing to unequal settlements under pressure. There have been times where clients will tell me, just sign off on whatever. I just want to be done. Just it's okay. Just sign off and give it to them. And it's not a place you want to be in, because while you want to be done very quickly, or while, you may feel intimidated to push back on an offer you receive, you have to protect your interests at the end of the day. And that is what we are here for. We don't represent both spouses. We represent one of you. And so we are always going to be putting your interests first. And that is what we would like to do. We don't want you to agree to anything under pressure or under duress that you're going to regret later on. Another pitfall is ignoring the value of non-monetary contributions. Remember earlier we talked about being a stay-at-home parent, or being the only child care for if there are children involved. Even though it's not a monetary contribution, and some people may say it's just, I'm just picking up around the house, I'm just cooking, I'm just cleaning, or whatever it is, those are still contributions and they should be talked about, because it could be the reason why you get a disproportionate share, or why certain assets are coming over to your side and not the other side. So any contribution you make during the marriage should be talked about in the realm of property division. Lack of post-divorce financial planning. Before you get into the divorce, you are going to want to create a budget, because you're going to want to know, how am I going to continue with my standard of living and be comfortable at least after this divorce is over and there's only one income in the household. You don't want to get up to the point of a divorce and finalize it and then not know what's next. So while you're in the process, and even before, be planning out and mapping out, how is everything going to look when this is done? And then not considering future expenses. This goes right in line with what we were talking about that budget. When you make that budget, don't include your spouse's income. Include all of your debts, all of the things you have to pay for, or whatever it is that is in your, coming out of your money, and include that and consider all of those future expenses. So even if right now you feel I'm very secure where I am financially, and you have to consider that that's because there's maybe two incomes in the household. So consider what it will feel like when there's only one income, and consider all those future expenses that may come up later on down the road. Ignoring court orders. This is not something that you want to do. This is a sure way to end up back in court years later after a divorce is done, is by ignoring court orders. When it comes to a court order, especially with property division, it is final. That's what it is. Unless you go back to court to ask the judge to modify something, that is what it is. It's done. Even if the parties agree to do something different, there could be implications for that later on as well. Then refusing to compromise. Don't come to the table, very stubborn like, and digging your heels into the ground. You're going to want to hear each other out, and at least try your very hardest to reach an agreement that both of you can live with, right? That's the only way that divorces don't get ugly, is if both parties are willing to come to the table and communicate together. And lastly, don't rush the process. Divorce is more of a marathon than it is a race. And so it takes time. Divorces are not a quick turnaround. It's not something you jump into and then you're done a month later. It's going to take months. And some divorces last longer than that. Of course, it's fact specific as far as the timeline, but don't rush the process. Let things be done in the timing that they need to be done in. So if you avoid these common pitfalls, you will be in a good position to resolve a divorce in a way that sets you up for success later on and protects your financial well-being as well.
Thank you so much, Jasmine. That was very informative and very well put. Thank you. Now, attendees, you all have the opportunity to write in some questions. I do want to put some parameters on this, since this is a recorded session and we will be posting it. Any questions that are very personal in nature will need to be modified before I read them aloud, just to make sure that everyone's privacy is respected. But if you have questions, please go ahead and put them in there. Or if you'd prefer to maybe meet one-on-one with Jasmine or one of our other team members, you can scan this QR code and we can schedule you a session. Okay, I will give just a few moments for some questions to come in, and then we'll go from there. All right. Jasmine, we have a question. Once divorce mediation is finalized, can the terms of the agreement be amended? For example, if both parties initially agree to sell the family home and each are due to receive a percentage of the profits, could one of the parties change their mind and contest the mediation agreement? If so, what is that process? So the first question is, once divorce mediation is finalized, can the terms of that agreement be amended?
So a mediated settlement agreement is binding and irrevocable. So once the terms are written down, everyone signs, it is final. And the only thing left after the mediated settlement agreement is written up is that all those terms are put into a final decree of divorce. So none of the language should change from the MSA, the mediated settlement agreement, to the divorce decree.
Perfect. So if one of the parties is wanting to change the percentage of the profits and contest that, that would not be allowed, or is there a process to try to contest that?
Yeah, really good question. So if one party wants to try to change the terms, they're not going to be allowed to do that because that agreement is binding and irrevocable. If you are wanting to amend it, the only way I would see that happening is if both of you are in full agreement to either go back to mediation to change it, or to draft up another agreement that kind of knocks out the previous terms. So if there's nothing else in writing and it's just relying on, oral agreements and that sort of thing, it's not going to work and it won't be enforceable in court, because that MSA will stand until, you all agree to something else or go to court or on it or whatever it is. So neither of you can change it unilaterally by yourselves.
Thank you so much, Jasmine. All right. We have a question about personal property. So there were there's a couple slides it's referring to about personal property. What is the most common unknown type of personal property that someone might have?
Oh, as in like the most common one that people just don't disclose, maybe?
Or that people aren't aware is personal property, I think might be what they're trying to say.
Oh, I'm not sure. I mean, when we think about personal property, it can be just about anything that's not real property, like rings or furniture or, things like that. So I don't know what the most common one would be that people don't think about. In a lot of situations, when we talk about dividing personal property, we normally don't list out, who's getting the microwave and who's getting the couch and who's getting the table in the master bedroom. We normally don't list out small items like that of personal property. The only time we list it out is if they have some kind of significance to them or if it's separate property. So if I'm saying, hey, that couch in the living room was the last thing my dad left me before he passed away, I'm going to ask for that specifically. Or if there's a painting that was gifted to me and it's separate property, I'm going to ask for that painting specifically. But everything else, normally the parties just agree to divide up whatever the personal property is.
Thank you so much, Jasmine. All right, we have another question. How long can you be separated before hiring a lawyer and starting the divorce process? And will a delay impact separating of community property?
Okay, so let me answer the first one for you. You can be separated as long as you want before starting a divorce process. There's no exact timeline for when you have to file. It's really up to you. So you'll look at your own situation and say, okay, when's the best time for me to file? Some people want to get all their ducks in a row before they file and move out. Some people are ready to just file immediately. And also when you file, you don't have to immediately serve the other party. So the process can start as slowly as you want, but once the other party is served, then both of you kind of determine the timeline. And then there are going to be some pros and cons to waiting to file and being separated. And that's because even while you're separated, community property still occurs and still accrues. So if you've been separated for a year and then you go buy a new car, that new car is still community property, even though you're separated and not living together. So if you wait to file, just know that there's going to be more property that comes up that can be divided in the event of divorce.
Thank you so much, Jasmine. We have another question. It was mentioned that court orders are enforceable and final. What is the process if your spouse ignores the court orders?
Yeah, so if there's a violation of the court order, what the next step would be to ask the court to enforce that order. So we start an enforcement proceeding with a motion for enforcement, listing out all the violations and the dates of those violations, asking for either fines or, in very serious situations, jail time, if that's going to be a problem as well. And so you would have to initiate an enforcement suit and ask the court to enforce it based on the court order. So just be sure to document every violation because the details will need to be in that motion as well.
Thank you so much, Jasmine. We have another question. What do you do if there aren't really any assets in the divorce except for pensions? And what would the procedure be concerning pensions as far as spousal support goes?
Yeah, so if you're not dealing with, properties or cars or anything like that, the division won't be as complicated as in a case where there may be businesses and stocks and that sort of thing. So when we talk about retirement, whether it's, defined benefit plans or pensions or, whatever it is, then what you'll need to do is figure out what the community portion of the pension is. So if this is a job that this person had only went after you all got married, so say you got married and then the person got the job, so all of the pension amount, all of the retirement monies are during the marriage, then it's all community property and you should get 50% of that. If they had the job prior to marriage, then you'll need to get information about, okay, what's the separate property portion and what's the community property portion, because you're not going to be allowed to divide up whatever they had earned prior to marriage, because that's their separate property monies. And so the way that we divide up retirement is you'll need to have a qualified domestic relations order. It's a QDRO. We call it a quadro for short. And basically it's going to divide up the pension or the retirement by percentage. So it won't say, give me $50,000, but that document will say, okay, 25% goes to spouse A and the rest of the 75% is spouse B's portion of community and their separate property. Then the plan administrator will open up a separate account for you. And in that separate account is where, all the money that you're due will start to be paid out to you on the timeline that the other spouse is paid out. So when they get a check, you get a check. And so that's how that part would work about the pension.
Thank you so much, Jasmine. We don't have any other questions in the queue. I'm going to give just a few more seconds to see if anyone else has a question or needs further clarification on a question maybe they asked. And during this time, again, I would encourage anyone who's maybe beginning the process of thinking about getting a divorce or is currently separated or is currently maybe even doing it on their own. You can schedule time with one of our attorneys, one of our team members to ask some great questions. So please do so. Use the QR code or you can call Kimbrough Legal. All right, I think we were able to answer everyone's questions today. Great job, Jasmine. Thank you so much for sharing the wealth of knowledge that you have. And thank you so much to our attendees for joining us today. We do have monthly webinars. We encourage everyone to join us. There's always a lot of advice and guidance given by our fantastic attorneys. Thank you all so much. Have a wonderful October.
Thank you.